Welcome to Let's Talk About It with Daisy Gates. So, we are going to continue to talk about the history of copyright in the United States. I gave you a little bit about myself before, and I would like to add to that is I have two music degrees. My first degree, what I received from Florida Memorial University. Back then it was Florida Memorial College. And I received my Bachelor's of Arts in Popular Music. Many people always ask me, what is that? I'll explain that later on down the line somewhere. And then I decided to go back to school and get my master's degree from Florida International University. And that is known for short FIU. And I received a Master's of Science in Music Education. All right, so let's go ahead and talk about the history of copyright. I'm not going to be before you long with this. It's going to be quick, fast, and in a hurry. And it's up to you to go do your own research on these webs, not social media sites, but on these webs. They have certain places. You can even go to the library and get on these academia and these JSTOR things and these history things that are for free when you are at the library, just to give you a heads up. Let's get on into this copyright history. So let's go ahead and let's talk about the history of copyright pertaining to the music side. If you want to know the in-depth history of copyright, you can go ahead and research that yourself. But within the copyright history, music came along later on. Though copyright had existed in other countries for some time and was introduced in the U.S. in 1790 for things like maps and books. You know what? The United States did not include musical works in its federal law until 1831 during a revision of the original Copyright Act. What was included in that revision pertaining to music was musical compositions. Now, let's talk about sound recordings. Before February 15, 1972, sound recordings weren't protected by federal copyright law, but rather by individual state laws. So, just to let y'all know, this is a little something that's very important that you need to know. Sound recordings are copyrighted separately, okay? Musical compositions are not considered the same work under copyright law, because I just told y'all that sound recordings was not introduced till later on. So I'm going to say this one more time. A sound recording is separate from a composition. Just to let y'all know, this is very important information. Okay, generally, sound recordings are copyrighted separately from the copyright of a musical composition, as they are not considered the same work under copyright law. Okay, hope you got it because I said it twice. October 28, 1992. Royalties introduced on sale of digital audio recording devices. So the Audio Home Recording Act provides for royalties to performers and copyright owners of sound recordings and to writers and publishers of musical works upon the manufacture and sale of digital audio recording devices and media. October 17, 1995, Digital Performance Right and Sound Recording Act of 1995. It provided the copyright owner of a sound recording an exclusive right with specified limitations to perform the recording publicly by means of a digital audio transmission. So December 20th of 1996, the international treaties addressed digital technologies. This was the beginning of online. So the World Intellectual Property Organizations copyright treaty and also their performance and phonograms treaty were adopted to deal with the protection of works, sound recordings, and performances in sound recording and the rights of authors, producers of sound recordings, and performers in the digital environment. In October 28, 1998, which is the Digital Millennium Copyright Act. What had happened was the Digital Millennial Copyright Act provided the implementations of the WIPO Copyright Treaty and the WIPO Performances and Phonographs Treaty. It limits online infringement liability for internet service providers, creates a form of protection for vessel holes, and clarifies the role of the Copyright Office. In November 2nd of 2002, the Copyrighted Works in Distance Education. What had happened was with this is the Technology, Education, and Copyright Harmonization Act of 2002 provides for the use of copyrighted works by accredited nonprofit educational institutions in distance education. On April 27, 2005, there was the pre-registration introduced. So the Artist Rights and Theft Prevention Act allows for pre-registration of certain works being prepared for commercial distribution. July 1st, 2007, electronic copyright registration begins, meaning that you can go online. They had a website that is made available to the public for you to do an electronic registration of your things to be copyrighted. Isn't that awesome? June 25th, 2014, the Supreme Court rules that online streaming services may be a public performance. So the Supreme Court holds in American Broadcasting Companies Incorporated versus Arrow Incorporated that Arrow services of providing online streaming to paying customers was a transmission of a work to the public. So July 8, 2019, Copyright Office designates Mechanical Licensing Collective and Digital Licensing Coordinator. So basically, the MLC, which is the Mechanical Licensing Collective, will administer the new blanket license and distribute collected royalties to writers and music publishers, as well as develop and maintain a comprehensive database of musical works and sound recordings, which will be publicly available. The DLC, which is the Digital License Coordinator, will represent digital music services in the administration of the license and in the determination of the administrative assessment fee paid by digital music providers for the reasonable costs of establishing and operating the new Mechanical License Collective, MLC. December 22nd, 2020, the Congress passes Case Act of 2020 in law regarding unauthorized streaming services. So basically, the Congress enacts the Copyright Alternative and Small Claims Enforcement Act of 2020 in a law on penalties for certain digital transmission services that make unauthorized uses of copyright protected works for profit, both as part of the Consolidated Appropriations Act of 2021. The CASE Act establishes a voluntary streamlined adjudication process in the Copyright Office to consider copyright matters for claims that do not exceed $30,000. So this was a history, my copyright history pertaining to music, what I thought was important. You can go online and go deeper and deeper into research of certain things that I did not include on here. But anywho, I just want to thank you for taking the time out to listen. So you can like, share, dislike, don't share. It doesn't matter. As long as you came here to hear me say this part, I really appreciate you. And have an amazing day, night, or morning. Bye.